Hello, welcome to the second series of our Supreme Court. I wish you have gone through our first series of the Supreme Court, which is very important. Then and then only come to the second series. So let's moving towards the power and the jurisdiction of the Supreme Court. This is extremely important topic if we want to write in prelims examination, because one or other way direct questions get asked directly with the power and jurisdiction of the Supreme Court. Here we need to make note that if the jurisdiction and the power of Supreme Court wanted to increase the area of this jurisdiction and the power of Supreme Court, then Parliament has the authority to do so. If we compare that with the US's Supreme Court, then this authority is actually given only in the Constitution. So it is quite limited for them to expand the jurisdiction of the Supreme Court. I hope you are able to understand it. So there are now 7 jurisdiction are there into the which is written into the Constitution. First is that original jurisdiction of the Supreme Court. Second is the writ jurisdiction. Third is the appellate jurisdiction. Fourth is the advisory jurisdiction. Then court of record. Also there is a judicial review, and last is the other powers of the Supreme Court. So moving further towards the first of our series is the original jurisdiction. So the name itself says that the Supreme Court has the original jurisdiction. So in the name we can say original means the appellate or the appellant person can directly approach to Supreme Court rather than approaching to the High Court. This is known as a original jurisdiction. It simply means the final authority to approach is with the Supreme Court, not with the High Court. This is known as a original. It is in the hand originally to the Supreme Court. So let's move towards what are those federal disputes. This basically original jurisdiction actually handles the federal disputes. So which are those federal disputes? There are basically 3 federal disputes that's handled by the Supreme Court under the original jurisdiction. Exclusive authority is in the hand of Supreme Court. Please make note of this. So first is that if there is a dispute between Government of India, that is center, and with the state. Second is if there is a dispute between Government of India in one side and the state. In the one party there is a Government of India and the state, and in the another party there is a state or more than 2 states. Okay, and in the third way there is a dispute between one state and the 2 or more state in the another party. I hope you are able to understand. In the first case we have seen that Government of India and the state. In the second case there is a Government of India and one state with another party, 2 or more states. And third way there is a one state in one party and maybe 2 or more states, or maybe a single party, a single state in opposition to that one state. So these are the 3 federal disputes this directly handled exclusively by the Supreme Court. Now moving towards, and also remember that we don't need to do appeal to the Supreme Court. We can directly go to Supreme Court without the appeal under the original jurisdiction. Now some are the limitations are also there to the original jurisdiction. We need to remember all of them. Please recall it, by heart it, because directly questions can raise from this topic. So the first limitation is that you need to remember is that no private member can approach to the against the government, maybe a state government or the Government of India, to the Supreme Court. So private member cannot appeal through the original jurisdiction. Also the corporates, that those cannot appeal to the Supreme Court. Second is that interstate water dispute cannot be handled under the original jurisdiction. You must have gone through the article 262 says that if there is an interstate dispute, there has to be a tribunal, water tribunal between the 2 states. So this is also not handled by the Supreme Court. Third is that whatever finance commission matter associated with the finance commission, we cannot approach to the Supreme Court. Fourth is that whatever expenses and pensions are between the center and state. If some members are working into the central government and their pensions and expenses, or maybe from the state government, then if there is a dispute between on the matter of the finance, pensions, they cannot approach to the Supreme Court. Sixth is the damage by state. It simply means that if taken hypothetical example, if there is uprootment of the rail track or maybe vandalism of the any government building of the central government, because the central government buildings are official buildings are also there into respective states. If that vandalism happen over there, or maybe uprootment of any public government, central government property is done, then also with this matter, the matter cannot go to Supreme Court through the original jurisdiction, even though this matter is between the center and state, but still this does not come under the federal dispute, and the Supreme Court, the both the parties cannot approach to the Supreme Court. Also remember that the commercial nature dispute cannot be addressed over here. Commercial, it simply means that if there is a take an example again, there is a coal mining or the coal area is there associated into a particular state, maybe a Jharkhand, Odisha, Chhattisgarh, and if there is some dispute happens between the center and the state government, then also this matter cannot be addressed under the original jurisdiction. I hope you are able to understand. And remember, Article 131 actually talks about the original jurisdiction. Sometime UPSC asks question where there is a maybe match the following pairs, or maybe some statement directly given, and we should know under which jurisdiction some matters are coming. Also, we need to discuss something over here is that, remember, nowadays UPSC is not asking direct question like which of the following are the limitations of the original jurisdiction. They will not come, they will not frame this sort of questions. So question will be that they will directly give some hypothetical situations or application, and they will ask whether this issue comes under the original jurisdiction. Take an example, if they will say there is a dispute between the Kaveri river water distribution between the state of the Kerala and maybe Tamil Nadu. So does that matter goes to comes under the original jurisdiction? Of course no, because under Article 262 this has to be handled by Kaveri Water Tribunal. So this will not be approached under the original jurisdiction in the Supreme Court. On the same line with the uprootment of the or vandalism of the any like central government property, that state cannot go to, or the central government cannot approach to Supreme Court, and there is not at all any relation of the personal individual member or a private member or private citizen to go to Supreme Court. I hope you are able to understand it. Now, we need to remember over here one thing is that I have always mentioned there is a state and government of India, or maybe one side the government of India and state with the another side to the two or more states. You have to make and you have to understand that what is the meaning of state. If you actually go through the articles of a constitution in little sensitive manner, you will understand that under Article 12, Constitution has mentioned about the state. But now the state definition, if you go to Fundamental Right chapter, you will understand the definition of the state is so much elaborative. But that definition of the state does not applicable under the Article 131, which is actually mentioned under the in 1936 under the state of Bihar versus the Hindustan Steel Private Limited, because there was some issue regarding the coal area what happened. So Hindustan Steel Limited is not the state, because that corporation can be defined as a state under Article 12 but not under Article 131. So here the definition of the state is extremely limited, so we cannot expand that to the corporate or any other entities that is there in the Article 12. So don't associate the definition of Article 12 with the Article 31. Please make note of this. Now we've done with the original jurisdiction. What you need to remember is that there is Article 131. Original simply means that exclusive authority of the Supreme Court to handle any federal dispute issue. I already mentioned that three things under which this issue get handled, and some of there are extreme important limitations are there. Also, the definition of state, which is there under Article 12, has not been seen with perspective of the Article 131. All right, moving towards the writ jurisdiction. Now, this is again a very important part to remember, revise and recall it n number of times. So what is a writ jurisdiction? Basically, writ in a simple way, it is like issuing order. The orders that is issued by the Supreme Court is known as a writ. Again, this writ jurisdiction is not exclusive power of the Supreme Court. You have to make that. Even High Court has authority to issue the writ. Even what is written in even though what is written or what Parliament can do is that, okay, fine, going back. Now, High Court has a wider jurisdiction in the perspective of writ than the Supreme Court. It simply means that Supreme Court can issue the writs only in the with respect to the fundamental rights. under Article 12 to 35. Okay, I hope you are getting it. But in the respect to High Court, the writ can be issued along with the fundamental rights. It can be issued on another issue and another matter as well. So the writ jurisdictory power of the High Court is greater than the or the wider than the Supreme Court. But also remember that Parliament can ask the Supreme Court to issue the writ on any other matter that it seeks for other than the fundamental right. You have to make this and you have to drill this sentence in your mind, because these are quite little tricky topic or tricky sentences that get framed in the UPSC, and yet I have not seen this sort of sentence in the previous questions. But this is quite tricky because Parliament has authority to increase the writ or the area of the writ of the Supreme Court. I hope you are understanding it. So now you need to go through important writ of the Supreme Court. So there are around 5 writs is there associated with the Supreme Court. First is the Habeas Corpus. Second is the Mandamus. Third is the Certiorari. Then there is the Prohibition. And there is one more left. I'll see. Quo Warranto. Now all of these writs are very important to understand. So let's move towards the Habeas Corpus writ. So what is use of this Habeas Corpus? The simple meaning of the corpus is the body. Under this writ, Supreme Court can issue an order to release any person who has detained illegally, unlawfully by the state or maybe by the individual person. Okay, so here we can understand that this writ can be issued against the government or can be against the private member. Please make note of this. For example, there is a girl who has detained by any private person on any issues. So then that person can go to Supreme Court and ask to get released under the Habeas Corpus. And as we know that under Article 22, that person has to be submitted or has to be presented in the Supreme Court within 24 hours. You must be knowing about it. This was a Habeas Corpus. Understand that this writ is issued against the private member as well as the government member. Okay, then what is against, as I already told you, that public officials or a private person. Moving towards the next writ is that Mandamus. Again, this writ is very important. Okay, now the second writ is a Mandamus. What does it mean? It simply the writ when the writ is issued only when the public office, it could be president, it could be governor, or maybe any quasi-judicial body, or maybe any judiciary, which is not performing as per their duty or as per the law, then this writ is issued by Mandamus writ is issued by the Supreme Court. Please remember here, private member is against the private member, the writ is not issued. Only the Habeas Corpus basically is issued against the private member. In the Mandamus, president and governor is also part. If Supreme Court feels that the president, governor, or any judiciary, or any tribunal, or any administrator is not working according to the duty, then this Mandamus writ is issued. Third is the Certiorari. This is again meaning that to quash the order which is passed by the judiciary or the quasi-judiciary body or the subordinate court. It simply means if that can be, suppose High Court has passed some order which is against the constitution that Supreme Court feels, then Supreme Court definitely can quash that order, which against include only the inferior court, then tribunals and quasi-judiciary body. And also remember, please, administrative department is also against the administrative department also this certiorari writ can get issued. Please remember that word administration in the certiorari. Moving towards the fourth writ is the prohibition. It again simply means that to prohibit the inferior court to give their jurisdiction. What does it mean? In simple way, if Supreme Court feels that the jurisdiction is given by a High Court, they will just scrap their order or prohibit giving their jurisdiction, or maybe High Court, maybe the subordinate court as well. Remember, administration is not the part of this prohibition writ. That means the prohibition writ cannot be issued against the administration. It can be only issued against the certiorari. I hope you are able to understand. And you have to remember each and every sentence of this word. Then there is a quo warranto writ. What is that quo warranto? It simply means that to asking what is the warrant that you have to conduct the office of that particular government. It simply means that to restrain a person. Remember that this quo warranto writ is issued against the public authority only. It means that whoever are holding the public authority under the government office, it simply means maybe an IAS officer or maybe subordinate officers or maybe state government officers. But this writ cannot be issued against the ministers. It means that we can't go to ministers and ask them what is the warrant that you have to carry your duty. Okay, if you're understanding it, then take it in very practical examples that only the there must be some cases that happen and we read it in the newspaper that there was a fake IPS officer some or other way in our country. Now, in that case, the Supreme Court can issue this writ of the quo warranto that do you have any warrant, do you have any authority to take this in charge of that particular office. I told you that this is not applicable to the ministers and also with the public authority. It means that private officers, you can't go into any company CEO and ask them, do you have any authority to discharge your duty? No, it is not supposed to be done. But what interesting factor we need to remember among these all writs is that all above four writs are directly associated or directly the person who are actually engraved because of the situation or maybe are the victim because of some situation, and they only can go to the Supreme Court and the Supreme Court issue the writ against some another authority. But with respect to this quo warranto, that even non-aggrieved person and the interested person can also go approach to Supreme Court to issue the writ of the quo warranto. It again simply means that if I am a person, if I am a victim, and if I am a victim, then I can directly go to Supreme Court. If the issues those are matter with the habeas corpus, mandamus, certiorari or a prohibition, then I as a person, as a victim only can approach to the Supreme Court. But if the quo warranto comes, then on behalf of me, some other member can also approach to the Supreme Court to issue the writ against the culprit. I hope you are able to understand. Make each and every line clear where the certiorari can be issued against the administrator. Yes. Whether is it issued against the mandamus, you have to go to the. There is no private member included into the mandamus. I hope you understood that with the habeas corpus, the private member against the private member also that writ can be issued. With the quo warranto, only the members, those are public officers, can be against them only this writ get issued, not with the ministers and the private officers. I hope you are able to understand it. This was about the second writ jurisdiction, which is under Article 32. We have already gone to the article. So Article 32, where the Supreme Court can issue the writs, and under Article 2, I don't remember, 266 I guess, where the High Court can issue the writ. Moving further toward the next jurisdiction of the Supreme Court. Now this jurisdiction is again very, very important because this is an appellate jurisdiction. Now what is meaning of the appellate jurisdiction? It simply says that a person, can appeal to the Supreme Court against any matter. And there is 3 appellate jurisdictions are there with the Supreme Court. First with the constitutional matters, second with the criminal matters, and third with the civil matters. Here remember, in the appellate jurisdiction, it always get appealed into the Supreme Court against the subordinate court or against the High Court. This appeal is actually, we ask the Supreme Court to give us justice against the decision that is given by High Court or maybe from the subordinate court. What you need to remember over here is that the Indian Supreme Court has all of this authority to appellate in the appellate jurisdiction, like constitutional authority on the constitutional matter, criminal matters and civil matter, and also special petition. But with respect to American Supreme Court, there is only constitutional matter get handled by the Supreme Court. There is no civil or the criminal or special petition in the Supreme Court of the USA. I hope you are understanding. Sometime UPSC also give one statement regarding the Indian Supreme Court and another statement regarding to the Indian Supreme Court, Supreme Court of India. Moving to in the appellate jurisdiction, you need to remember the article 131. Also, you need to remember article 134, 135. Those are actually concerned with the appellate jurisdiction. Now we'll move towards the first appellate jurisdiction is known as the constitutional appellate or constitutional matter. What does it simply means that if the High Court feels if High Court is giving jurisdiction on a particular matter, and if the High Court itself feels is that I am not able to interpret some constitutional matters, then that issue can directly go to the Supreme Court. If any matter has to be actually interpreted by the High Court, but if he unfortunately could not able to interpret that matter, then that matter directly go to Supreme Court is known as the constitutional matter appellate jurisdiction. Second is a civil matter. Again, what does it mean? That law of general importance. Generally, some laws are important or some facts are important. Sometimes High Court could not able to again decide that final interpretation or cannot able to give some verdict on behalf of them, then directly that issue under the civil matter goes to the Supreme Court. I hope you are understanding. In the constitutional matter, only the constitution High Court is not able to interpret. In the civil matter, High Court is not able to understand or interpret or give verdict regarding the civil matter. Those may not be the part of constitution. Again, remember, after the 13th Amendment Act, some limitation of this monetary limitation has removed, and now a person, if even rupees 1, there is issue to interpret to the High Court regarding the even rupee 1's matter, civil matters, then also that issue can go to the Supreme Court. I hope you are understanding. Before that, civil matter has to be at least of rupees 1300 or 1300, I guess. But now there is no limitation of the monetary. Monetary limitation is not there now. Now moving towards the third is the criminal matter. Now this is very important. I just hope that if you go through the book, you will be able to understand. But probably the people does not understand if they read it once and it finds little hectic. It finds really tedious to understand the word of this constitution or the Lakshmikant. So what is the criminal matters? You need to understand over here is that, we'll take an hypothetical example. There is a Supreme Court, there is a High Court, and there is a subordinate court. Now in the first condition, listen, there are 3 conditions are there in the criminal matters. In the first condition, if it happens is that, suppose subordinate court has given some verdict against the accused, and he has said that the person is now free from his any sentences. Okay, if a person, take an example, if X person has did some if X person is a victim and he had done some criminal activity, but Supreme Court says that I will free this person from his sentence because we are unable to gather the proof or the person is innocent. Now the people those have filed the appeal against this victim will approach to High Court, and now High Court will say that High Court will give the verdict that this criminal or this accused will get the death sentence or can get the 10 years of the sentence or maybe like life imprisonment. Okay, this is the first condition under the criminal matter. Now in the second condition, you understand that if the district court announce any verdict, if the district court is about to announce its verdict, about to means in the future, about to announce its verdict, but before that itself the High Court give its verdict and give that accused and life sentence or maybe again a 10 years punishment or maybe a death sentence. So here also, this is the second matter. Now in the third matter, High Court themselves says that we are unable to give verdict regarding that particular matter, and the matter will go to the Supreme Court. Now in this first situation, remember that the person who is accused and who has been sentenced any death sentence or any rigorous punishment sentence, that person can direct approach to Supreme Court under the criminal matters of the appellate jurisdiction, and Supreme Court can give his final verdict and quash the order given by the High Court. I'll repeat it once again. I don't know how much you understood it. So there is a criminal matter. There are 3 matters we need to understand over here is that there is a Supreme Court, High Court and subordinate court. If in the first condition, subordinate court has give the sentence that the person or the accused is innocent, then if that matter is actually appealed by another party to the High Court, then High Court, if he gives a death sentence or the 10-year punishment or maybe life imprisonment, the person who has given, or the accused who has given the innocent stag, that person can directly approach to Supreme Court against the criminal matter of the appellate jurisdiction, and Supreme Court can squash the order given by the High Court. In the second condition, if the subordinate court about to give any verdict, or district court about to give any verdict, and before that itself, if High Court has given the verdict, this is not at all allowed, then the appellate or maybe the person who is accused can directly approach to the Supreme Court into the criminal matter under the appellate jurisdiction, and the order given by this High Court can be squashed. This is the second condition. And in the third condition, High Court themselves says that we are unable to give the verdict on the matter, and you can directly approach to the Supreme Court. Under this, all the matters, criminal matters, get over. Now moving towards the special leave petition. Article 136 talks about the special leave. Now this appeal by the special leave is also a very important topic in the perspective of prelims. So what is this appeal by the special leave? Take an hypothetical condition. You have already filed a complaint against somebody else into the High Court, and High Court decision comes against what you think of. So even the same line with the tribunals or maybe subordinate court. So what if you wanted to take a justice from the Supreme Court? But in practical manner, if you wanted to challenge the jurisdiction of the High Court in the Supreme Court, you need to take permission beforehand from the High Court, which is mentioned under the Article 134A. But now, by the appellate of special petition, we can directly approach to Supreme Court and to seek a justice against any court or any tribunal, except the martial court and also military tribunal. Please remember, we cannot file the special leave into the Supreme Court against the martial court and the military tribunal. So there are 4 important aspects we need to remember regarding the appeal by the special leave. I am not saying it is a special leave petition, because petition and appellate has some difference. Okay, but we are not going into depth of that. Just remember, this is just appeal, not a petition. Okay, now remember over here, which are those 4 aspects that we need to remember into the special appellate or special leave. The first is that this is the discretionary power of the Supreme Court. It is not the right. We cannot ask Supreme Court to give jurisdiction on that particular case that we are appealing into the Supreme Court. It is their right. It is their conscience to think whether to give jurisdiction on that particular case or not. Please make this point. The second thing is also important to remember is that it is granted to any jurisdiction under the territory of India. To any jurisdiction, it simply means that the jurisdiction, it could be the final jurisdiction or it can be interlocutory jurisdiction. If you'll actually study the previous article 132 to article 134 or 5 for that sake, all of this, we can appeal from this article where the jurisdiction is the final order of the court. Okay, but with this special leave, we can appeal to the Supreme Court the final decision of any court or any tribunal, or maybe interlocutory decision. It means the decision may be in the half of this final proceeding or the final order, which is not given by the tribunal or the court. This is the second. What we learned in the first is that important. It is the discretionary power of the Supreme Court. It is not the right that we should ask them to give a decision. Second is that it is granted to any judgment. It could be the final judgment or it could be the interlocutory judgment. Now third is the Supreme Court can handle any matter which is under the special leave. Which are those matters? It could be the matter those has to be handled by the court or maybe by tribunal or maybe quasi-judicial bodies or maybe any advocate, or it could be what they have mentioned is the income tax, or maybe from any civil or criminal proceeding of the any court or the tribunal. So if we're actually approaching to the High Court or subordinate court, or as we have learned into the jurisdiction of the Supreme Court into the appellate jurisdiction, there was only, we say, a criminal or maybe a civil jurisdiction was also there in constitutional matter. But here now all the matters are actually get involved. There is basically limitless power that Supreme Court got under this Article 136. So if you have any concern with the income tax officers or income tax decision tribunals, then you can directly approach to the Supreme Court under the special leave. On the same line with the advocate in the same line with the criminal and the civil matters. Now the fourth is important, is that it can give the jurisdiction against the court or the tribunal, as I already mentioned, but not necessarily which has to be passed by the High Court. It simply means that not necessarily the jurisdiction that is given by High Court and then only we can approach the Supreme Court. No, if the jurisdiction is given to by subordinate court, we can directly approach to Supreme Court under the special leave, or against the tribunal there is no need to go to the High Court. We can directly approach to the special leave appeal. We can appeal to the Supreme Court under special leave. But we need to make the note over here, as I mentioned, that this is the discretionary power of the Supreme Court, whether your case has to handle or not. This is not our right to ask them to give us justice. Please make this note very clear. I hope you are able to understand. Those are very important topics. So we have done till now whatever things we have done, the jurisdiction and power of the Supreme Court. First we done with the original jurisdiction. Then there was this writ jurisdiction. Please go all this writ jurisdiction under Article 32 of the Constitution, and then we done with the appellate jurisdiction recently. So in the further slide we will do with the leftover jurisdiction of the Supreme Court. Thank you.